Hi, chat. How are you guys doing? Put your ear down, sir. This is in public. People could see you. Anyways, hey, chat. Welcome to the show. Welcome to the show. It is Thursday night. Yes, it's Thursday night, and that means it's time for the Thursday night show, because otherwise it wouldn't make any sense if it wasn't Thursday night. So it's okay, buddy. My name is Sean, also known as Potential Criminal. I'm an attorney in the Cleveland, Ohio area. And tonight, well, this is Clyde. Well, we've got a lot to talk about. We've got kind of a not surprising Second Amendment setback. We've got a very based response to it. Then there's also some good news from the DOJ, surprisingly from the DOJ. Then we've got some Bowhunters securing a big win for not only just themselves, but for people trying to access public land. We got some Trump updates. And then we've got some just interesting things that are going on out there. And it's going to be a very, very good time. And we are looking forward to it. So tonight we are live on Rumble. We are live on Twitter. And we are also live YouTube. And then last but not least, Locals chat. And if you don't know what Locals is, potentiallycriminal.locals.com. Locals is everything people want Patreon to be without all the bullcrap that Patreon has. So with that, at potentiallycriminal.locals.com, you can join in for free. It costs you nothing. You can participate on the wall that we have out there, post things, respond to things. I respond to things. I'll post things. If I try to give you guys a heads up on things, I try to post it over there. So it's a great way to stay updated on things. And then if you wish to support me over there, it's $3 a month. You pay for 10 months, you get 2 months free. And with that, you get access to the live shows. We do live shows Monday nights. I'm starting about 8:30 to 9 o'clock-ish. And then we also do a live show right after this. Every Thursday night, we do a live show. We get to hang out. All the stuff you can't talk about here. All the stuff that wasn't appropriate here. And just in general, a place to have fun and relax. We get to do that. We also do some fun stuff like Formula One started, guys. So the Chinese Grand Prix is going to be this weekend. When Mr. Medicare goes live, we always hang out over there too. It's always a fun time. And that's at potentiallycriminal.locals.com. Use the promo code WHIPIT for 1 month full access. So you get access to the live shows. I'm sure you guys will enjoy it once you're actually sticking around. So once again, please try that. Let's see what else we got people doing tonight here. Aquila says, I can attest that Sean is on Twitter, but it's usually a ghost town over here. No one to build towers with. Well, that is what happens. That is what happens on Twitter. Twitter says like, oh, there's like 700 people watching. You're like, but they're not real. I know they're not real. Thank you, Aquila. Then David over at Making Law Simple says, are you talking about your OnlyFans striptease? No, not yet. Not yet. I got to say, you got to keep people waiting, man. Got to keep people waiting. And Watcher, hey, man, how you doing? It's good to see you. Good to see you, man. It's like in the mountains, it's only like 8 o'clock or 7 o'clock or something. So there you go. There you go. But anyways, good to see you, man. I gotta DM you over on Twitter tonight, but I'll do that. So good to see you. Oh, who else is here right now? Common Lawyer, hey, how you doing? Armand, hello. Watcher's saying they are real. The issue is Rumble is saying the wrong metric. If you log in, X will tell you they are views, not live viewers. Oh, well. So people view it for like a second. Okay, so I got some interest out of some people for a second. Anyways, Clyde, I got to put you on the ground, buddy. You're a little too much to hold at once. Okay? Also, chat, I forgot to mention, if you go over to Locals, we have a live chat that's open now where you can say all the things you can't say here. And if I happen to see them and it's funny and I could say it, we'll talk about it, or if you share a meme. So, where's Clyde? I'm going to sit you down, buddy. Okay? All right, Bubba. All right. So, yes, Clyde. Yep, Clyde is taken off. Clyde is chunky. He's just very hairy. He's very hairy. Although I will say, if you guys go on Locals, 2.0 helped me get the pictures. I found the pictures of Clyde when we first got him as Gotcha Day, and right afterwards, and he was all skin and bones. You can see his spine. Now that he's also been groomed up properly, I think that's more of his hair than anything. Because when he gets his hair cut, you'll be like, oh my gosh, he looks so skinny. All right, so what else we got here? The little Gen that could. Hi, Jen. Okay, what else we got here? Jonathan, how you doing? Half Irish says Clyde needs one of those baby carriers so I can be hands free. 2.0 has one of those for the cats, so when she's working, the cat can just hang in it while she works. Like it's a real thing. It's a real thing. Nico's saying, wait, Ethan Ralph and DSP are gonna have a stream? Wow. It's gonna be interesting. It's gonna be interesting, to say the least. To say the least. All right, guys, we normally give people 10 minutes to catch up in here, but we're gonna check a couple things real quick. Ace Hanlon says for $2, how and why do federal judges overrule Trump's orders? Because the Supreme Court allows them to. I mean, like, there's the whole idea of a check and balance, but I think you're more saying, how does a district court judge do it? And it's because nobody tells him he can't. That is the reason why. Because a court above him hasn't told him ne pas. That's why he does it. That's why he does it. I wish there was a better answer than that, but no, that is truly the answer we're at. And we're going to talk about that kind of like, there's a little bit of a legal update and kind of also going into what some of the actions and reactions are to some of the things, including the trendy arugula deportation lawsuit. Because I know that's a big one right now, the trendy arugula. Chugi Show is saying, here is some coin to order new business cards that say nickel lawyers because the penny is obsolete. Well, thank you. Thank you. I appreciate that. Also, I was on time, so you don't have no comment tonight, huh? Squizgar is saying boot Pam Blonde. Boot Pam Blondie. Bish needs to get on the 2A EO. Well, like I said, we're going to talk about that. DOJ is doing something kind of based. We'll see how well it works. And Colostomy Bag is saying, Sean, I didn't have a girlfriend a week ago, and now she's sleeping in my room. We went shooting, and now she's tired. I mean, that sounds like a good problem to have. I mean, what's not to love about that? What's not to love about that? Sounds like you found a good one. Sounds like you found a good one. So keep it up. Good job out there, King. Just make sure he doesn't kill you in your sleep. Am I going to use the TTS system, the super tip system? No, I'm good. I don't really need the super tip system. I'll be all right. I'll be all right. Stacy says, how does she feel about the bag? What bag? The I don't know. Huh? What? I'm confused. Sounds like he's about to lose 50% of all future earnings. Well, that's a secondary issue. And that Shame says no one ever fucking, going back to the judges, no one ever fucking tells them they can't. And that's true. And we're going to get to that. Quill is saying no such thing as a judicial check on the president or Congress. Any such suggestion is judicial supremacy and a grab for power. Well, yeah, but, the way the institutions have set themselves up, they've recognized judicial power, so it's there. They've endowed it with that power. Going all the way back to Marbury versus Madison. It's their job to say what the law is. No. Bama's saying, do you simultaneously stream Rumble as well? How's your numbers there as to BoobTube? Oh, nobody. Like, there's Nico's over on Rumble. Then Jody 121 says, I tickled the plussy button. That's really it. I mean, like, there's nobody over there, but a lot of people want it, so I just put it up. It doesn't cost. Like, Rumble lets you do like so many slots per thing, so I may as well put it there and like do it. So it's okay. It's okay. Hold on one second, chat. I'm gonna fix something here. So, just overturn Madison or grow balls like Jackson and say fuck off. To overturn Jackson would literally you're taking basically a torch to all Supreme Court jurisprudence, and you're just which at times sounds really good, but that's what you would literally have to do. At least in my opinion. Yes, I'm like, okay, I mean, while we're talking about it, like that's on the same vein as, and this is where I'm going to be honest with you guys. That's on the same vein as like before the summer's over, Clarence Thomas is going to be like, you could have a crate full of Uzis in your house and nobody can arrest you for it. Like that ain't happening. That ain't happening. So, all right. So it's time to get started, chat. Here we go. All right. So first things first, we'll start off with some Second Amendment news. Now, the first thing we'll start off with the bad stuff first. We'll start off with the bad news first, and it's kind of bad. I mean, it's bad news. It's bad news. It's not good news. It's not good news. Okay, it's not good news, and we are going to deal with this here. So it's out of the Ninth Circuit today. I'm sure you guys have already heard the story and heard the score. The Ninth Circuit has overruled the magazine. So they upheld. Sorry, we'll just say that. They upheld the reversal of St. Benitez's magazine ban. But you guys remember, this is a challenge to the California limit on magazines that hold more than 10 rounds. This is also the case that led to Freedom Week. And if you guys don't remember what that is, there was when Judge Benitez down in San Diego declared that the magazine ban was unconstitutional. There was about a week time where you could get a hold of magazines that were more than 30 rounds. There was known as Freedom Week for all the Californians. So they took advantage of it. And yes, that went back up, and it was an en banc hearing at the Ninth Circuit. And guess what they did? They said lol doesn't count anymore. And they overturned everything. And yeah, I mean, are you really surprised? Are you really surprised? That's that's kind of the issue here. And this is a massive opinion. It's a massive opinion. In fact, it's something I'll probably go over later. The biggest problem with it is it's 147 pages in total. There's a lot of dissents. There's a lot of stuff that goes on in it. And yes, now you guys might say, well, what was the historical precedence? How do they do it? They just said because. I mean, that's reason. We talked about this before. When a court wants to get to a conclusion, it will twist the law, it will twist the words, and get to that conclusion. And there's not a whole lot you could do about it. They're going to get to it, and that's where it's going to be. So that is what's happened here, and this is no different. This is no different of a situation. And just so you guys understand, here is the case. It's Duncan v. Bonta. This is the big one here. As I stated, it's 147 pages. So we are not going to touch that tonight. That is probably another thing for another day. Maybe I see if I can get Matt, Funbuster, see if I can get Runkle to hang around. We'll take a look at it, but that's what we're dealing with. So anyway, this is just kind of the issue here. So the Ninth Circuit upheld the magazine ban, reversed the San Diego judge. So yes, guys, if you don't know what we're talking about 30-round magazines typically, but anything bigger than 10. So almost all handguns, especially nowadays, all handguns, if you got more than 10 rounds, and almost all of them do, can't have those. So what happened? It was a 7-4 decision. It was acknowledged, or was authored by one of the senior judges, Susan Graber, which is very funny. Grabber. She's a grabber. She's grabbing the guns, chat. Well, that's what she's doing. And she wrote that a large capacity magazine has little function in armed self-defense, but it's used by mass shooters. And they also decided these are not arms. These are not arms under the definition of Bruin. So they sidestepped their way through it. It's not very impressive in the bullshit they did. But what they did very good, what did happen was very good. Is one of the judges who did something here. There were dissenting opinions, and one of them was authored by a judge, Lawrence Van Dyke. So Judge Van Dyke, he It's a very interesting thing he does. And I guess, you know, from my understanding, Bronca showed this and got away with it. So I hope we can get away with it tonight too. But he didn't get nuked. Now this guy, Judge Van Dyke, he's an attorney. He was appointed by Trump. He is the former Solicitor General of Nevada and Montana, or Nevada, or Nevada, whatever you want to call it, the place where Las Vegas is, and Montana. He was nominated by Trump. He was there, and yeah, it's good stuff here, guys. So he ended up doing a dissent, and he did a dissent in probably a very, very based way. He did it in a very based way. So this is where I was really surprised because I don't know how he got away with this. Just because, and if you guys were not aware, the Ninth Circuit, and we'll just open this up so you guys can see. The Ninth Circuit covers this area of the United States. So it covers, you know, if you weren't sure where it is, it covers Arizona, Nevada, Arizona, Nevada, California, Oregon, Washington, Idaho, and Montana. Covers all these states. And this is where I'm thinking, I got some concerns. I got some concerns here. But this guy did it, and he made a video dissent. And it's interesting because I don't think I've seen one of these before. And this was posted. This is Judge Van Dyke, and here it's posted, chat. It's on the Ninth Circuit of Appeals. It's on the Court of Appeals YouTube channel. Yeah, it's on the Court of Appeals YouTube channel. So what is this? What is this?
Hi, I'm Judge Van.
So this is Judge Van Dyke, and you notice he's got up on the wall already. Pretty based. We're already starting off pretty based, chat. I don't know where it's from, but we're already there. We're already there. Now, I don't know where he's at, but I'm assuming, anyways, he goes on to this, and he starts talking, and he starts going through, and he starts talking about why these judges got things wrong. And then he gets on to doing a visual demonstration of why things are wrong. And we're going to start here.
Show you.
He's going to show you. He's going to show you, chat. And I've got the sound up all the way. Let me see if I can boost this just a bit more. Okay, here we go.
So let's do that now. Welcome back. To demonstrate, I'm going to start with this SIG P320. That's basically...
Notice he's got fucking guns in his office, which is based, mega based. And he's got a SIG 320 though. So you're just like, no, Judge, you're going to shoot yourself. You're like, no. He's going to it's going to go off. You guys, the SIG 320 jokes, they just write themselves. But yes, he's going to hurt himself because the gun's just going to go off on his own. But yeah, this is bad. This is bad. It's so scary. But he's got a revolver. He's got everything there. He is a competitive shooter. But this is actually, it's pretty impressive what he does.
In a stock configuration. That is, this gun is basically in the same configuration it would come to you from the manufacturer and be sold to you at a retailer. This is one of the most popular handguns currently on the market in the United States. And so I'm going to use this to point out some of the essential parts of a handgun. These same parts would exist on pretty much every handgun, at least of this semi-automatic type. So let me start by pointing out a few of them.
Okay, so chat, if we get nuked, we're going to keep going on YouTube and Twitter. I'm not going to stop. So anyway, if you see him, he keeps going here. He's holding it.
This one comes with a standard 21-round magazine. Comes from factory just like that. You can buy a similar.
Which, how does he have those in his, is he in California doing this? Or is he in, Nevada? Or is he in Montana doing this? How is he doing this? Where is he doing this from? Where is he doing this from? I don't get it. That's right. I don't know. He's like a 21-round magazine like this, which is illegal in California. It's like, how? Yeah, it'll absolutely be Montana. That's what I thought too, but you never know. That's the only thing I think can make sense. So the map on the wall looks like Montana. That's what I thought so too, but you're never sure. You're never sure. But anyways, he keeps on talking about these guns and he's holding them up. He's talking his way through them. It's 18 minutes long, chat. I listened to it already. It's very based. Very good job.
Version that comes with a 17 round magazine that fits flush. And so comes with 21 or 17 round magazine. It has a standard full size grip.
So he goes on to talk about it. He puts, he starts
and thus wholly.
He starts talking about all the guns he has and he starts holding them up and playing with them. And he moves on.
And when you do that, you can put the 2 screws back.
He talks about with the SIG, he takes the side off, and then so far the SIG has not gone off and shot anyone.
Back into a red dot optic, and now you will have a firearm that instead of having iron sights would have a red dot optic. Let me illustrate that by just taking a slide where I've already installed the red dot optic, and here you go. See, so now you have this back iron sight's been taken off, and here's a red dot optic. Now, in the hands of an experienced shooter, this red dot optic allows you to shoot the firearm more quickly, to get on target more quickly, to hit what you're aiming at, be more accurate. And so it's obviously much more dangerous.
And he is true. It's much more effective as it's got all these things. He starts talking his way through the other guns he's got up here. But as he does this here, look what he just does.
The key part of a firearm is the grip of a pistol. Well, actually, under the majority's argument, it would not be protected. And the reason is, here's a bunch of grips that I've accumulated over the years. I'm just going to pull a couple out here. This is a nice small grip, a nice small light grip. This is a big, heavy grip. So what you can do on this firearm is you can remove the slide, remove that takedown lever, take what's called the fire control unit out of the firearm. This is actually the firearm under the ATF's definition. And you can take this fire control lever and you can put it inside the smaller grip. And you could use this grip for, say, self-defense purposes because it's very concealable, it's light, it's easy to carry.
Yeah. So he goes on through this and he gets to be a little gun honest. He's like, I'm going to play with my guns in front of you. Which I think is pretty based. And he's just talking about how wrong they are. And he's
with a highly unrealistic idea of how such a rule would be administered in real life. Ultimately, the only rule that makes sense and comports with reality and the text of the Constitution is that the entire handgun here, including the grip, this takedown lever, the slide and barrel, the sighting system, and this magazine are all part of the arm within the meaning of the Second Amendment. Thank you for watching.
And that's the thing here. That's part of the issue, is that none of this other stuff counted as arms, which is completely stupid. It doesn't make any sense how you could separate the accoutrements and the other pieces and equipment from being an arm. It's all part of the thing. So, and especially for magazines in modern firearms are a critical piece. It's part of the operation. Without it, you have a single shot firearm, and even then, a very cumbersome to use single shot firearm because you have to chamber load each time. It's a pain in the ass. It's actually kind of hazardous. So, yes, without a magazine, it's very difficult to load many firearms. So, detachable magazines are old tech now. Yeah, over 100 years old at this point, detachable magazines. There were detachable magazine pistols in the 1890s that were mass produced. So, especially the magazine disconnects they level. That's a separate thing. There. So, that's a separate issue, chat. That's a separate issue. Where's the part where the judge fires it? He's just going to open up the window to his office. Just. Ellis, is that a porn set? I don't know. What is wrong with your voice? Did you swallow an entire pond filled with frogs? No. Do I sound that different right now? Hold on.
Is this better now? Let me know. Better one, better two. Keopathics is the 1911s detachable magazines, true world wars, and even more Ninth Circuit rulings. You know what, though? I'll show you one better. The Beretta M9. 2 Gulf Wars. That's right. And an entire war on terrorism. Beat that. So, ribbit. Oh, no. Oh, no. All right. Well, so that is kind of the interesting thing there that happened. I mean, the Ninth Circuit shot it down, and it's absolute garbage they did, but it's interesting what they came to. Now, on a positive note, this is where we get to the positive note tonight. The positive note is what's going on with the DOJ. And the DOJ is actually going to do something pretty productive here. And this is where you're like, oh, wow, Pam Bondi's involved in this. So the DOJ is going to create a path forward for people with criminal convictions to again own firearms. And this is just the basic rule or the story on it. The DOJ plans to create a process to allow restoration of gun rights. And this is part of Trump's executive orders that were put out there to assess any ongoing infringements. And yes, this is the point here. The ATF has had the power to restore gun rights. Congress has allowed it to have this authority, but they have been denied the ability to do so because Congress has denied it funding to specifically do that since 1992. Now, what they're arguing is the DOJ is going to do this through their own department, through the Department of Justice. And what did we see here? Well, guys, this is where the Federal Register takes over. This is where the government puts out things that are going on. It prints regulations. It prints things that are out there. It also does notice to changes of rules. It also does propose rulemaking and notice periods. And this one here is a great example of what's going on. So it's the Department of Justice, Office of the Attorney General, and it talks about 27 CFR Part 478 and 28 CFR Part 0. And it says, withdrawing the Attorney General's delegation of authority. And the agency that's involved in this is the Attorney General. Talks about the action. They're looking for an interim final rule, and they're doing a request for comments. And they say this interim final rule amends the Department of Justice regulations relating to the ATF by withdrawing the effectively moribund regulations regarding how the ATF will adjudicate applications for relief from the disabilities imposed by certain firearms laws and withdrawing a related delegation. And they say the effective date, this rule is effective March 20th, the interim final rule. And they say written comments must be submitted on or before June 18th. So, guys, there is a comment period, and people are allowed to produce comments. So, if you want to support this, you can advocate in support of the thing. Normally, when it's the DOJ and ATF making a rule, normally we're like, no, stop. But this is one time where we're like, this actually might not be a bad idea. Let's give it a shot. Let's try it. Let's try it. Like, let's see what happens here. So this is the good news. This is some good news here. Now, is this going to turn into anything real? I don't know, guys. But you know what? We got nothing else to go off of, so we got to try. We got to try to work with this, all right? So they talk about the addresses. If you wish your comments to be involved in this, you reference it, use these reference numbers. This is just all the basics of how you respond to it. So now you move on, and they talk about a little more here. They say for further contact information, they talk about public participation. So you can submit if you're interested in the rulemaking, you can do this by submitted written data, views, or arguments on all aspects of the rule. They're also inviting comments that relate to the economic or federalism effects that might result from the rule. Anything you want to do. They say comments must be submitted in English or accompanied by an English translation. But once again, they tell you how to do it, where you could go available and make all your comments if you want to do this. And they say if you want to submit personally identifying information, As part of your comment, but not want it to be posted online, you must include the phrase personal identifying information in the first paragraph of your comment and identify what you want redacted. Because if you don't, they literally just put your whole part of the federal rulemaking process and, FOIA and just in general, the idea that we make this known for everybody, your shit just gets right on there. So you got to be careful. You have to be careful. The personal redacted information we placed on the public docket file, but not posted online. So make sure you're careful. If you submit confidential business information, but you don't want it posted online, you have to do it. You have to tell them it's confidential business information. But now they're talking about the statutory framework. And this is where we get to the good points and the actual interesting parts of this. So federal law prohibits several categories of persons for possessing in or affecting commerce any firearm or ammunition. That's 18 U.S.C. 922G. They say by statute it also provides that any person who's prohibited from doing this may make an application to the Attorney General for relief from that disability. And the Attorney General may grant such relief if it is established to his satisfaction the circumstances regarding the disability and the applicant's record and reputation are such the applicant will not be likely to act in a manner dangerous to public safety, and the granting of the relief would not be contrary to public interest. And they say, they talk about 18 U.S.C. chat. The first version of this was enacted in 1968 as part of the Omnibus Crime Control and Safe Streets Act of 1968. And whoo! That was some sneeze in chat. And they say initially the Secretary of the Treasury, and that's because the ATF initially fell under the Secretary of the Treasury, was empowered to provide relief only to a person who has been convicted of a crime punishable by imprisonment for a term exceeding 1 year. And it says, other than a crime involving the use of firearm or other weapon or a violation of this chapter or the National Firearms Act. So there were some limitations even back then. And then they point out that over time, however, that authority was transferred to the Attorney General and expanded to allow the Attorney General to provide relief to any person who is prohibited from possessing, shipping, transporting, or receiving firearms or ammunition. And they say, and to allow such person to make application to the Attorney General for relief. And they say the regulations establishing the process to implement the relief were also first promulgated in 1968. Yes. Remember, chat, promulgating is just the idea of creating and developing. They say initially those regulations were delegated to the Secretary of the Treasury and the authority to adjudicate applications to remove disabilities under 18 U.S.C. And they also talk about to the Commissioner of the Internal Revenue Service. So they talk about all the things that happen here. And they say under Title 11 of the, Section 11111 of the Homeland Security Act of 2022, the authorities and the functions of the assets of the ATF are transferred to the Department of Justice instead of the Treasury Department anymore. So they got moved. And they say, in short, the HSA created two separate agencies. ATF in the Department of Justice, and that's when they say the department, that's what they're referring to, and the Alcohol and Tobacco Tax and Trade Bureau in the Department of the Treasury. And that's because they still are part of the taxing arm. And that's true, chat. If you brew alcohol, you have to pay tax. If you're doing tobacco, the government regulates you. You have to pay tax. Oh my gosh, you guys are ridiculous. Oh wow. You guys are. And they go on to talk about everything that happens here. And they say, moreover, the Homeland Security Act expressly provided that the Attorney General may make such provisions as the Attorney General determines appropriate to authorize the performance of any officer, employee, or agency of the Department of Justice of any function transferred to the Attorney General under this section. So they talk about what this is going to allow for here. And they say, in doing so, the Homeland Security Act made clear the primary functions of the ATF we're investigating criminal and regulatory violations of federal firearms, explosives, arsons, alcohol, and tobacco smuggling laws. So, as well as other crimes and domestic terrorism. And they say it also amended 18 U.S.C. 925C to make it clear that an individual seeking relief from disabilities must now seek relief from the Attorney General. And they say pursuant to the statutory authority and consistent with the historical practice, the Attorney General delegated the authority as opposed to, relieve disabilities to the ATF. They say this delegation was effectuated through a final rule that took immediate effect and was exempt from notice and rulemaking. And they talk about where it is, and it's 68 Federal Register 3747. And you can look this up if you want to. They said in the early 90s, Congress became concerned about the number of resources the ATF was using to adjudicate requests to relieve individual Americans with disabilities on their firearms. And this is what Congress said it was the excuse for defunding this situation. They didn't like it. And a committee believes that there were approximately 40 man-years spent annually to investigate and act upon these investigations and applications. We better utilize the crackdown on violent crime and put black people in prison. Thank you, Joe Biden. They say congressional reports also stated that judging whether applicants pose a danger to the public was a very difficult and subjective task, and that too many felons whose rights were restored went on to commit crimes with firearms. Citation needed. So, to allow the ATF to return to its core function of investigating violations of federal firearms laws, and they talk about what they did here. Congress provided in 1992 that none of the funds appropriated herein shall be available to investigate or act upon applications for relief from federal firearms disabilities. So that is why this happened. They said, we're not arresting enough people. We need to do more. They say since then, the ATF has been unable to effectuate its regulatory authority to act on individual applications due to identical appropriation riders enacted annually. And that's true, guys. Every year this happens. It happens. And they cite the Consolidated Appropriations Act of 2024. It always gets included. And they say here, they talk about the proviso where that's happening. They have not stopped doing it. Now, they say ATF, however, is able to act on applications for relief from disabilities filed by corporations, which are historically far less common. And it says, though, that such funds shall be available to investigate and act on applications filed by corporations seeking relief from firearms disabilities. So isn't that interesting? It's interesting. And they point out that it has not received such an application since 2018, rendering the ATF's existing regulations effectively moribund. And they say, nevertheless, as noted above, when it comes to the past thing, Congress chose to transfer authority to remove individual firearms disabilities from the Secretary of the Treasury to the Attorney General. As a result, 18 U.S.C. 925 continues to provide a remedy to remove disabilities for firearms possession for certain individuals, even though the ATF has been unable to act on any application since 1992. And they say this is a confusing state of affairs, and it's taken on greater significance given the developments in Second Amendment jurisprudence since 1992, which at the time was none. Like, thank God Heller didn't happen in 1992. God, we'd been walking around like fucking slingshots by now. That'd be bad. So they talk about Executive Order 14206, done on February 6th, protecting Second Amendment rights. The President, Donald John Trump, reaffirmed our national commitment to the Second Amendment as an indispensable safeguard of liberty and security, and directed that within 30 days of the date of this order, the Attorney General shall examine all orders, regulations, guidance plans, international agreements, and all other actions of executive departments and agencies to assess ongoing infringements of the Second Amendment rights of our citizens. Yes. And at the time, I was like, oh my God, nothing's going to happen. And chat, this is actually something happening. Like, this is actually a good thing. This is a good thing. If this actually can happen, I'm thrilled because people deserve the opportunity to have their rights restored. They really do. So they say, consistent with this order, The department has begun a review in earnest and will provide the president with a plan as required. So the department recognizes there's no constitutional right is limitless. It also supports existing laws that ensure, for example, violent, dangerous persons remain disabled from acquiring firearms. They say from the department's perspective, regardless of whether the Second Amendment requires an individualized restoration process, 18 U.S.C. 925 reflects an appropriate avenue to restore rights to certain individuals who no longer warrant such a disability. And they talk about based on the combination and nature of their past, their subsequent and current law-abiding behavior, while screening out others for whom full restoration would not be appropriate. And they say, however, the ATF, which currently has the regulatory authority to act, has been forbidden from utilizing any of its appropriated funds for staffing. And it's true, over 30 years, chat. So they're going to go in and they're going to take it away from the ATF. They're going to take it away and they're going to say, we're just going to do it under the Attorney General. They say it's also undertaking broader examinations of how to address the drain on resources that caused Congress to impose the rider in the first instance. So we're going to doge it up, chat. So we're going to doge it up. So what they're going to do, and they're going to go forward with this, and they're going to point out what they want to do. And so they talk about what the actual actions of what they're seeking to do here. All right. So when they say consistent with the rider, the process described here will not be transferred to any other agency or department. They say at the same time, it's conferred on the Attorney General, and no applicable statute restricts the Attorney General's authority to delegate that authority or withdraw a prior delegation or amend prior rules. So they're saying the Attorney General can withdraw this, and we're not officially creating anything new. I'm just revoking things and returning it back to my authority. So that's why they're making such a statement here about what this is going to be, hopefully. And they'll be able to take it away from the ATF because now they won't be stopped with funding. I'm the Neil deGrasse Tyson of YouTube lawyers. I don't know if that's good or bad. So they say, thus the Attorney General is withdrawing her delegation of authority to the ATF by revising a delegation of authority in 28 CFR 0.130 and removing 27 CFR 478.144. And when you see CFR, chat, that's the Code of Federal Registers, and it's the actual where you find regulations. So like all the ATF regulations and rules that are out there, you find in the Federal Register, in the CFRs, you'll find them there. That's also where you see, like, for the FAA, you have like Part 95 and Part 135 of the FAA regulations. That's where you have those things. So JL says, who's in charge of this? Well, we're going to get to that. So they're talking about all this does, it provides a clean slate on which to build a new approach to implementing it without the baggage of unnecessary procedures. And they want it to give full effect while ensuring that violent or dangerous individuals remain disabled from lawfully acquiring firearms. So notice they have to, this is part of your regulatory requirements. You have to talk about the Administrative Procedure Act. When they say notice and comment is unnecessary because this is a rule of management or personnel as well as a rule of agency, organization, procedure, or practice. So there are times where notice is not required. Notice is not required and comment is not required sometimes. And they say, for the same reasons, this rule is not subject to a 30-day delay in effective date. They say the interim rule relates to an internal delegation of authority and relates to a matter of agency, organization, procedure, or practice. And they say removing effectively defunct regulations addressing how the Attorney General statutory authority will be exercised does not adversely affect members of the public and involves an agency management decision that is exempt from notice and comment rulemaking procedures of the Administrative Procedures Act. Now, you guys notice those are all special words that matter there, where you talk about the management decisions and, that it's not adversely affecting members of the public. It's all internal. We're internally changing something. Therefore, it doesn't matter what we do with the Administrative Procedures Act. And they cite a bunch of cases here that back them up. And they say this rule is exempt from prior notice and comment in a 30-day effective date because it relates to a matter of agency, organization, procedure, and practice. And that goes on again. They keep talking about it. And they say for similar reasons, the original rule delegating authority also did not go through a notice and comment process. They say in contrast to the Department of the Treasury's 1968 rule that set forth substantive standards for consideration. They say because the existing rule was published, however, the department nonetheless has in its exercise of discretion deemed it appropriate to publish its revocation in the form of an IFR. So that is what they're doing here, chat. This is all the beginning here. This is a notice. This is a notice that they are doing this, and they are doing an interim final rule. This is how you notice all these things. And they say, due to the significance of the removal of firearms disability process, it's also providing the public with the opportunity for post-promulgation comment before the department issues a final rule on these matters. So they're pointing out, we're giving you the opportunity, but we don't have to give you the opportunity. But this is very important. Now, obviously, people are going to oppose it, but once again, chat, you guys can go out there and comment on it. This is kind of a big deal. This is kind of a big deal. So go out there and show them your support and say, yes, help people out who need it. And obviously do a good job making the bad guys stay away. But people who paid their debt to society and are square with the house should have their rights restored. So this is a positive thing. And they're pointing out they want you to make comment, but they're graciously allowing it. They say providing such an opportunity is not, however, committing the department to waive its exemption from the APA's notice and comment process and this or future rule makings regarding the removal of firearms disabilities. So what they're pointing out is even though we're kind of waiving our ability to do what we want, now we are not doing that in the future. They're reserving their rights every other time. They talk about the Regulatory Flexibility Act. This is an analysis that's not required when a rulemaking is exempt from notice and comment rulemaking. And it's an internal agency organization, therefore it's exempt. The Unfunded Mandates Reform Act of 1995. Now, guys, these are things you have to do. These are all congressional laws. They say this rule will not result in the expenditure by local, state, and or tribal governments in the aggregate or by the private sector of $100 million or more in any 1 year. And that's something if you do, you have to note the analysis on this. And they say, therefore, no actions were deemed necessary under the provisions of the Unfunded Mandates Reform Act. They talk about executive orders, 12866, regulatory planning. They also talk about 13563, and that's improving regulation and regulatory review. Now, they're pointing out this rule is limited to agency organization, therefore is not subject to review by the Office of Management and Budget, the OMB, pursuant to Section 3 of the executive orders here. They say, nevertheless, they certify that this regulation has been drafted in accordance with the principles of that executive order and the other executive order. And they say these two orders direct agencies to assess the costs and benefits available, regulatory alternatives, and if regulation is necessary, select a regulatory approach that maximizes net benefits. There, and they say the benefits of this rule include providing the department a clean slate to reconsider its approach to implementing a scorecard and implementing a core constitutional right embodying a statutory authorization that has largely lain dormant for over 30 years. Yes, it's good stuff. This is good stuff, chat. They talk about Executive Order 13132. Talks about federalism. This rule will not have an effect on the direct effects on the states, on the relationship between the national government and states. But these are things that these executive orders are involved in. There's Executive Order 12988, civil justice reform. And this rule meets all applicable standards set for that. The Paperwork Reduction Act, chat. Remember, we talked about this. This is one of the things out there. This is how they were going after Trump with the stuff from the HHS websites that were being taken down. So these do not apply because there are no new or revised record keeping or reporting requirements. They say, does the Congressional Review Act do this? It's not a major rule as defined. And they say it's just it doesn't cover it. They say Executive Order 14192, it's a regulatory cost. And this is the Unleashing Prosperity Through Deregulation that was issued on January 31st. It requires an agency, unless prohibited, to identify at least 10 existing regulations to be repealed when the agency publicly proposes for notice and comment or otherwise promulgates a new regulation. They say further this requirement, the it requires that the new incremental costs associated with the new regulations shall be offset by the elimination of existing costs associated with at least 10 prior regulations. And they say this interim final rule is a deregulatory action because it withdraws the Attorney General's delegation. So therefore, we don't have to worry about that. Now, they talk about the list of subjects. It just says 27 CFR Part 478. Administrative practice, arms and munitions, customs duties and inspections, exports, customs, intergovernmental relations, blah, 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 blah. Talks about 28 CFR Part 0 and what it's going to do. And it talks about here, guys, if you guys want to know what these things are, how they're going to amend things. And this is actually a good example of the CFR when you're looking at it. Hold on. So, hold on, where was I looking for here, chat? What did I have up? Okay. So the authorization for this, and they talk about how this looks if you actually read the CFR. These are how it's like set up. It reads just like normal law, but it gives you all that granular stuff of like, well, I'm going to create the ATF. Okay. It's going to regulate alcohol sales and the creation of alcohol. Okay. Well, how do you do that? Well, now you have to go read the CFR. And the CFR lists out all the procedures, regulations, and rules that are out there. Now, who is this? This was dated March 12th, 2025 by Pamela J. Bondi. I guess she did something important here. And then you move on. The next one is an EPA, CFR. And it's a withdrawal of a direct final rule, which they can do. Notice there was a rule in place, and they're like, yeah, we're just going to bring that back. You have to publish all of this, and it all gets published in the Federal Register. So this is how you can keep track, but it's like everything that happens at once. So there's not a specific section you have to look through. You have to look through all of it. So it bounces around and covers everything. So that's the good news, chat. The DOJ is going to be trying to help people. So it's not a bad thing. I think you guys should do this. Did you miss the corner crossings? Not yet. So that move is what makes the ATF completely unconstitutional. Yes. So that lung syphilis is rough. I'm okay. Man, it was nice. It was 71 yesterday and it snowed today. That's how crappy it was here in Ohio. So that is where we are. Hold on here. What did I miss here? Nobody says, what is moribund? Moribund is something that's kind of like declining. It's kind of like its usefulness is degrading. Hold on here. What else is another? Hold on. It's lacking vitality or vigor. So there you go. That's another thing for that. So it's moribund. There you go. Eric says this format's nauseating. Yeah, but that's how you do it. Man. You gotta suffer. So let me see here. What else are you gonna go on? Let's see here. Oh, Ron over in Twitter. Hello, Ron. How you doing? Jarek says liking this stream is like hugging Sean. Give it a try. Thank you. Debony Doombringer says, "Hoy, do they have a license for this noticing?" No, they don't. Yes, Armand says this is not instrument flight rate rules. No, this is not that IFR. Oh. So that is where we are, guys. That's kind of the update with the Second Amendment stuff now. And let's see here. Squizgar is saying a crate full of Uzi in your house that ain't gonna happen. I said tread lightly because I tread on your dreams. Well, Aquila says I don't remember any historical precedents for the magazine size limit. It just goes to prove there's no such thing as judicial supremacy when they just ignore SCOTUS themselves. Very true. Very true. Very true. There's a couple more here. Eric Foam says the judge drops the SIG and he kills someone. Yes. That's very true. And Keopathic says if he's in California, law enforcement and politicians are exempt, even if he's in California. Okay. Keopathic says people hate the M9 because they abused them and they were FUDs. Yes. Been there, done that for 11 months. Thank you for the support, man. Is saying, where's the part where the judge fires it? Well, he didn't drop it on the ground, so there was no firing of it. Lolita Smile says, good, these guys deserve second chances. I think so, too. If you paid your debt, you should be allowed to do that. Stabby says, why isn't Trump pardoned Matt Hoover yet? I don't know. Hopefully that shit starts happening, but I don't think, I get the feeling it's not going to be happening right away. So yeah, that is kind of where we are. That is where we are, chat. That is the big news right now with the Second Amendment stuff. Moving on, I know, David, if you're still there, you might find this interesting. This is a case out of the Sixth Circuit, and it's involving the people suing the school, the Oxford School District, for the shooting that happened there when the school basically let Ethan Crumley walk around with a gun, and they didn't really do a good job at stopping him as he was getting ready to kill everybody. So, but anyways, the teachers were sued in federal court. The guidance counselor and the dean of students, which I'm pretty sure we saw both of them testify at the trials for Ethan's parents. And it's funny, they still got sued. They had to suffer. Well, the Sixth Circuit did release an opinion on this because it got appealed up. And the judge had ruled that they could be held to deal with it. Well, Sixth Circuit said not so much. Once again, chat, Judge Kethledge, he is one of the judges that when Kavanaugh was up, he was in the running for. I don't know if he's in the running anymore. He's getting a little older, so that time has probably passed him by, the Supreme Court of the future. And they talk about all the parties involved here that were argued and that were the parties that argued. And then on brief, everyone else. On brief means you wrote a brief and you were involved in briefing or an amicus brief. But if you argued, you were the guys who actually got to do the thing. So they talk about this, guys. It's only 7 pages, but it's interesting. So they talk about on November 30th, 2021, in Oxford, Michigan, a 15-year-old student took a gun to school and used it to shoot 10 students and 1 teacher. 4 students died. The shooter, whom we will call EC, and I think that, give him his fucking name. He earned it. He earned it on the pages of history. Pled guilty to first-degree murder, is now serving a life sentence. His parents are likewise in prison after juries convicted him of manslaughter, which is bullshit. Meanwhile, his parents, and guys, if you didn't realize this, the Sixth Circuit covers Michigan, Ohio, Kentucky, and Tennessee. It says, meanwhile, the victims of the shooting had brought multiple suits in state courts seeking recovery against school and law enforcement officials on various theories of tort liability. Many of those suits remain pending still, and they do. They say the consolidated cases here are different. What the plaintiffs assert here is not a negligence claim, but one sounding in a rare species of one of the narrowest doctrines of constitutional law. And they say, for the most part, the Constitution sets forth the rules for government, both creating its powers and limiting them. The limitation the plaintiffs invoke here is that of due process. And to proceed with those claims, the plaintiffs must allege more than that the school officials in these cases, a counselor and the dean of students, made bad decisions or could have done more to prevent the tragedy. What they must show is that the actions of these 2 defendants were so outrageous. Remember, Chad, it's outrageous. And so callous in their disregard posed by Ethan Crumley as to shock the conscience. Well, I think so. They brought him in and thought he was going to kill everyone, and they're not like, let's take a look in the bag. What do you got there, buddy? And they're like, oh, you dropped something, Ethan. Here you go. Have fun. So, did this not ship over, chat? I'm sorry. Sorry, chat. Sorry. It didn't. I'm sorry, guys. So I'm sorry that didn't come over here. So this is the Sixth Circuit case. We're going up here. We're going back down. It talks about the guys who argued it, the guys who were on brief. So there are a lot of people on brief. Not everybody got to argue. So they talk about the limitations here, and the district court held, with one exception, the plaintiffs did not allege any facts supporting inference to that effect. And they say we reach the same conclusions across the board, and thus we affirm in part and reverse in part. And they do say we accept as true the facts alleged in the complaints. And that in early November 2021, a student entered a bathroom stall and found a jar containing a severed bird's head. Ethan Crumley's journal revealed he had killed the bird and brought to school in the jar, though the officials were unaware of those facts then. Around this time, Ethan Crumley's Spanish teacher told a school counselor, Sean Hopkins, that Ethan Crumley seemed sad. So sad! Hopkins offered to talk to Ethan Crumley, but Ethan Crumley declined, yes. On the weekend before the shooting, Ethan Crumley's mother posted a picture of him at a range with a 6-hour 9mm semi-automatic handgun, which she called his new Christmas present. Based. School officials were unaware of that posting. The next Monday, the day before the shooting, an English teacher saw Ethan Crumley looking at photos of bullets on his phone. The teacher reported that to Hopkins and asked EC about the photos. And Crumley said guns were a family hobby. That night he wrote in his journal, "The shooting is tomorrow. I have access to the gun and ammo." On Twitter, he posted, "Now I am become death, the destroyer of worlds." Oh my God, so gay. See you tomorrow, Oxford. School officials were unaware of those facts too. And it says around 8:30 in the next morning, another teacher saw Ethan looking at his phone. This time he was watching videos of shootings. The teacher reported that to Hopkins. 30 minutes later, a math teacher found a worksheet on which he had sketched a pistol with a person with gunshot wounds and a bullet. On the same worksheet, Ethan had also written, "Blood everywhere. My life is useless. The thoughts won't stop. Help me." Well, you forgot your comma. That's probably why maybe nobody understood. The thoughts won't stop helping me. So the math teacher promptly alerted Dean of Students, Nick Ejak, and Hopkins about the worksheet. Within minutes, they escorted Ethan Crumley to the counseling office, where they retrieved his backpack from the classroom. They did not look inside the backpack. In the office, they had told that he had been drawing characters for a video game. Hopkins had said, "This doesn't sound like a video game to me." And they asked Ethan whether he was a threat to himself or others, and he replied, "I can see." He's like, "I can see why this looks bad. I'm not going to do anything." And notice they didn't look inside the backpack. It's like, well, there you go. There's your problem. They then called Ethan's parents, telling him he was concerned that Ethan was suicidal. They needed to come to school. They arrived around 10:30 that morning. They said that he needed immediate counseling that day if possible. Well, that doesn't happen. His parents said that was not possible because they needed to go back to work. Then when Ethan's still present, Hopkins told the parents that if they did not get counseling within 48 hours, he would call Child Protective Services. His mother asked, "Are we done?" Hopkins said yes. And I'm sure he's like, "Well, we're going to call Children's Services." And they're probably like, "Okay, fag boy." They say after the meeting, they returned Ethan's backpack to him and sent him back to class. Imagine how much that weighs on your fucking mind. You thought this guy was so dangerous, but you didn't grab his, you didn't check his fucking backpack. Like what a stupid Mama Luke motherfucker are you to do that? They say during the next 2 hours, Hopkins confirmed that Ethan arrived at each of his classes. Shortly after noon, however, Ethan left the class and went to the bathroom. He went to go put in some work, chat. He removed the 6-hour from his backpack, returned to the hallway, and just began. You know, like as Eminem said, you take 2 guns, spin them on your. Actually, Dr. Dre said this. He took 1 gun, spin it on his finger. He kicked the swinging doors and then started gunslinging. Oh yeah, Ethan started playing Duck Hunt. So they say plaintiffs later brought these suits, claiming the defendants have violated their constitutional rights to due process. The defendants moved for judgment on the pleadings, arguing they were entitled to qualified immunity. Yes, because they're government employees, chat. They get qualified immunity. The plaintiffs did not allege facts showing a constitutional violation. The district court largely agreed and dismissed most of the claims. But the court held that the statement to the parents during the meeting that he would call CPS potentially did support the constitutional claim. So everybody then appealed because they appealed for separate reasons, and there were cross appeals. And it says survive a Rule 12C motion. And Rule 12C, chat, remember, there's Rule 12B, and that's the one we always do. That's the one we always talk about. But a Rule 12C, guys, and Rule 12C is, and we're going to pull it up. Where is Rule 12? Hold on, I just lost it. Hold on here. Where I just had it up. I'm going to pull it up to show you guys. So Rule 12C is this motion for judgment on the pleadings. After the pleadings are closed but early enough not to delay trial, a party may move for judgment on the pleadings. And yes, you could do this. You could move for a judgment on the pleadings. Say, Your Honor, we've dealt with this. We're ready to go. And this is how it works. So it must contain sufficient factual matters accepted as true to state a claim of relief that is plausible on its face. And they review it de novo, meaning anew. They say they have jurisdiction over an interlocutory appeal. And this is where they're at, chat. It's an interlocutory appeal because the case is ongoing. And it's because the defendants argue they are entitled to qualified immunity. And this is normally what happens is you either get granted qualified immunity or deny it. And then you immediately appeal that ruling up to the circuit court. And that circuit court makes its ruling, determines how the case goes. Normally, if they say there is qualified immunity, you're kind of boned because that's it. Or they'll say there is no qualified immunity. And then, if you're suing, that means you're in a good spot. Now you could go forward on your case. And they say to overcome qualified immunity, the plaintiffs must show on a defendant-by-defendant basis that the defendant violated both the constitutional rights and the law that made the violation clear at the time the defendant acted. They say the showing necessary to satisfy the standard depends on the stage of the case. So they start out with, since this is in the pleading stage, they determine whether or not the plaintiffs plausibly allege particular facts supporting an inference that they violated plaintiffs' constitutional rights. And here they go to the Due Process Clause of the 14th Amendment. And they say that clause imposes a limitation on the state's power to act, not a guarantee of certain minimal levels of safety and security. They say, thus, by its terms, the 14th Amendment regulates only the state's actions, not those of private actors. They say, and here the person who deprived the victims of their lives was a private actor, EC, either Crumley. They say, but our current circuit has recognized a theory of state-created dangers, according to which, under narrow circumstances, state actors can be liable for harms caused by private actors. And they talk about the three elements this claim has. And there's a first action, the first part of it, the first prong. The state official must make an affirmative act that creates or increases the risk that a victim will be harmed by a private actor. They say, second, this risk must pose a special danger to a specific victim, meaning a danger to that victim greater than the danger to the public in general. And they say, finally, third, the state official's conduct must be so egregious, so outrageous, that it may fairly be said to shock the contemporary conscience. Yeah, you think this kid is so dangerous, you want him out or you want children's services involved, and you don't go, huh? Yes, they don't do that. They just let him, have fun. And he's just like, bam, 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 bam. It's like, okay. They say they agree with the district court that two of the putative acts at issue here can't support the liability. And they say, first, the plaintiffs arguing that the defendants created danger when, after the meeting, they returned his backpack to him and sent him back to class. It says, but those actions put the plaintiffs in no worse position than the one in which they would have had been had the defendants not acted at all. And that's correct, chat. So that's the thing. Like, if they had done that, does it change the situation? No, Ethan still would have shot them all. And they go back to the case of DeShaney versus Winnebago County Department of Social Services, 1989. And guys, we've covered this before. In DeShaney, DeShaney was a, what's the name? Was the name Adam or Kyle? Hold on here. What's his name? Joshua DeShaney. I'm sorry. Joshua DeShaney. He was a kid who was given, the court had awarded his dad custody over him. And dad moved to Wisconsin, and dad beat the shit out of Joshua routinely. They'd gone to the hospital before. Social workers had come over to the house, and they're like, They actually wrote in their notes. They're like, yeah, pretty sure this guy's beating the fuck out of his kid. That's lunch. And then eventually Joshua DeShaney was beaten so bad he became a fucking vegetable for the rest of his life. And he died, recently. But he died, because of complications of what his dad did to him, but beat him half retarded. So when you see DeShaney being cited, that's what they're talking about. And damn, I didn't realize that was still up. Jeez. Stabby. Killing me here. So they talk about Ethan had a backpack containing a gun before the meeting, and afterward he had the same backpack containing the same gun. And they say to avoid any misimpression, nothing in the record supports an inference the defendants knew the gun was in the backpack. They say for purposes of this theory, the act of returning the backpack did not satisfy the state danger requirement because returning something to someone to the same dangers that existed before is not enough. The same is true of the second act, namely that they concealed from other officials the risk that he might shoot other students in the school. And they set to one side the question of whether they perceived the risk as opposed to the risk that Ethan Crumley would harm himself. And they point out that concealed is a loaded term because the defendants failed to tell other officials about the risk he might harm others. But failures to act are usually not affirmative acts for purposes of this theory. And that's true, guys. Remember, the government doesn't have an affirmative duty to act. Neither do most government officials. They don't have a duty to act. So they point out that nothing in the record supports an inference that they sought to cover up any risk of harm. Now, they do move on, and they say the primary question here is whether the warning to the parents that he would call CPS if they didn't get help satisfied elements of this theory. And the district court thought that warning was an affirmative act because it increased the risk that a mentally unstable teenager would harm other students. And the court says, well, could debate that point, but less debatable in our view is whether that warning was so outrageous as to violate due process. And, this is where it ends, chat. They say, when as likely the case here, a state official can reflect before he acts, he violates due process when he perceives a substantial risk of serious harm and then responds to it in a manner demonstrating reckless or callous indifference. And they say here the actions show they perceived a serious risk. Okay. And they say, but the actions also show they displayed the opposite of callous indifference towards the risk they perceived. That is especially true of the very act on which the plaintiffs would ground liability. They said, namely, that Hopkins demanded that Ethan Crumley's parents get him into counseling within 48 hours. Hopkins made the demand to mitigate risk, not to increase it. And they say that his demand was indisputably made for a legitimate governmental purpose, which all but excludes a finding that it was, conscience shocking. And they say, as the plaintiffs say, though, this case comes up to us on the pleadings rather than summary judgment. But even taking their facts as true, we see nothing in the record that supports the inference. The teacher and the dean of students took any action that shocked the conscience. And they say that these claims sounded tort, not in federal constitutional law. And they say, thus, in these cases, their claims must be denied and dismissed. So, yeah, so there is a interesting case out of Michigan here that's helping kind of get some stuff out, which, it's at least somebody's winning in these cases. So, that is, like I said, it's an interesting idea here that these people are being forced to deal with it. Moving on, guys, we do have a thing here. So in Louisiana, a guy was actually ordered to return to prison. And this is how the Louisiana Court of Appeals. And it's the state of Louisiana versus Jeremy Eric Carter. And this is another issue we talked about last week where the sentencing had gone awry. And because the sentencing is wrong, they have to fix it. But to fix it, that means somebody has to go back to prison. So that is what they're talking about here. So they are dealing with this, and they say in 2011, the defendant was convicted of the offense of armed robbery in violation of Louisiana revised statutes. And then subsequently, the state filed a habitual offender bill seeking to have the defendant sentenced as a third felony offender, relying on his prior convictions. burglary and cocaine. And they say on April 2013, the trial court adjudicated him a third felony habitual offender. And they say under the hold on here. We're there. We're there, chat. They say under the offender sentencing guidelines, they were required to impose a minimum sentence of 66 years at hard labor. And in spite of this, the trial court imposed a sentence of 20 years at hard labor. And they say, although the sentence was clearly illegally lenient, the state did not file an appeal. Therefore, when legal days for seeking an appeal ran, the conviction and sentence became final. Which you're like, okay, that sounds good. Like, normally if you are on the other side as a defendant and you don't appeal right away, well, there you go. So in March of 2023, the defendant filed a pleading called a motion to correct an illegal sentence. In that motion, he did not contest the term of the sentence, but challenged the validity of the habitual offender adjudication. At the trial, as the trial court held the hearing, at the conclusion of it, it ordered that the defendant's sentence be reduced to time served and that he be immediately released. The state's like, whoa, we need to stay while we figure out what happens. So on September 25th, the trial court signed a written order amending his sentence to time served and releasing him. So the government filed a writ and a notice to appeal, shortly after, on the same day there. And then it filed a motion for appeal in November, asking the trial court to consider the initial notice of intent as timely. And it says the trial court granted the state's appeal, and the ruling is now before this court for review. So what happens here? And they say the assignments of error to the trial court erred in granting to the motion to correct the legal sentence. And the trial court erred in resentencing the defendant to time served, which is an illegal indeterminate sentence. They thought the trial court erred in resentencing the defendant to a term of years below the mandatory minimum sentence. And they say the trial court violated the separation of powers, unconstitutionally reduced the sentence, invading the governor's clemency and pardon powers. So you guys want more slurs? So hold on here. What is this thing you sent me, Ag? All right. Well, I'll look at this later. Sorry. We're going to get back to this here, chat. Did someone say slurs? Yes. Oh, Jody says over in Rumble real quick. You're a couple hours east of you, south of Toledo. Shitty weather. West of you. Yeah. Toledo's about 2.5 hours away. And they say, ultimately, they found the trial court lacked the authority to amend the sentence. And they'll say, first, why did they lack the authority? And then they say, next, we explain why the trial court applied the incorrect law in its decision at the hearing. So they say the petition filed is a motion to correct an illegal sentence. It's like, it is, however, the content of the pleading, not its caption, that determines its nature. And that's the thing. So you can call it whatever you want. The bigger issue is what's in the body of your motion. So they talk about how you do a correction of a legal sentence by a trial court, and it's through the criminal procedures code. And there's ways to do it. And they say on its motion, the state or the defendant, or on its own motion at any time, the court may correct the sentence imposed by that court, which exceeds the maximum authorized by law. So if you're only eligible to get 1 year in prison and the court gives you 20, it can fix that on its own. So though many inmates challenge their sentences at any time through the motions, they say, unless the claim alleges an illegal term, it does not constitute an illegal sentence claim. They say in the matter before us, there's no allegation, nor can the defendant identify any term in his sentence that exceeds the maximum authorized by law. They say in his pleading, the defendant, in fact, makes no reference to or argument regarding any aspect of the term of his sentence. He says his sole argument is that the predicate offenses do not support his habitual offender status. And they say that term of the sentence was not before the court. And they say, based on the content of the pleading, this can't be considered a motion to correct the illegal sentence. And they say, however, he may seek relief of his conviction through an appeal, an application for post-conviction relief, a motion to reconsider sentence, and a motion to amend his sentence. Each must be timely filed. And guys, the issue of post-conviction relief, that's like what the Menendez brothers are doing. That's all the things you see out there. Motions for new trials, motions to, open up the record again. All these different things. Those are post-conviction relief. Those are separate from an appeal. An appeal is in the time frame of post-conviction, but an appeal is generally different because that's generally something you're involved in as a matter of right. So that is why they're referencing there. And Auto Doctor saying, wait, the same court that sentenced him released him with time served? I don't know. That part's not clear to me. We might get to see it here. I think it talks about it here. So the defendant was sentenced almost 10 years prior to filing the motion before us. The statutory delays for seeking review through appeal, a motion to reconsider, and a motion to amend had lapsed when he filed the instant pleading. They say, in addition, we know that sentencing issues other than ineffective assistance claims are not cognizable on collateral review. So, guys, the way this works, when you do have post-conviction relief or you want to do all these other things that are out there, you have time frames. So that is how you do this. That is how these work. So there are very limited times you can appeal. There's very limited times you can get things sorted out. So you have to be very careful when you're in these situations. Then there's always ones you can always change. But collateral review is basically, when you think of collateral review, think of it like a habeas corpus petition. You're not challenging the conviction anymore, saying like, well, that wasn't fair. You're challenging it collaterally. It's called a collateral attack. And that's what most post-conviction relief is. You're getting a new trial. You're attacking other things than your conviction. So that is where we are. When they say, having reviewed the actual issue, the defendant argues the trial court erred by using his conviction for possessing cocaine as a basis for adjudicating him a third felony habitual offender. So they say, regardless of the title, this is actually an application for post-conviction relief, and we'll consider it as such. And they say, as an application for post-conviction relief, the pleading is bound by the prescriptive period set forth in the criminal code. And the defendant's judgment and conviction became final in May 2013. So that means he had 2 years from the date of his conviction and sentence becoming final to seek post-conviction relief. They point out he didn't file it until March of 2023, which is far after the time period for seeking post-conviction relief. Therefore, it wasn't timely filed. And they say, even though an application may be untimely filed, the trial court may consider the merits if a defendant both alleges and proves that it falls into one of the narrow exceptions to time limitations. They say his claim does not meet any of these exceptions. Oof, that was a little trying to do something funny there. Hey, buddy, you want to come here? Hi. Hey. You want to come here? And Clyde's just like, I'm going to sit down. So it's like, all right. Oh, come here, buddy. Hi. Oh, he's licking my hand. And they say, since all delays had run, the defendant's petition is considered untimely and should not have been considered by the trial court. We hereby find the claim untimely. For that reason, we deny his petition. They talk about the trial court, what the trial court did wrong here. And the sole issue was the legality of using the drug conviction. And they say the applicable law in 2009 clearly provides that the complaint of conviction could be used. They say, in addition to the issue being raised untimely, there's no legal merit to the claims. And they say, although there was no issue raised during the term regarding the term of his sentence, the trial court, sua sponte, meaning of its own accord, decided to review his sentence and ultimately amend it. And they say the following exchange took place, and they say, the judge says, I have a 2009 book. This is a 2009 book. So what does that mean, chat? So, for example, when you see these books up here, like different procedure books and whatnot, they come out every year with brand new ones. And the government always has brand new books because they can afford the exorbitant fees to get brand new criminal procedure books every year. So that's what they're talking about. But the judge went back and found one of these, and they keep them because it does show them what the law looked like at a certain time. So the court says, I don't want to see it. I'm going to agree. He says that they're going to agree with the defense attorney. The prosecutor says, and what? And he said, I don't think he should be habitualized. And he says, well, the prosecutor's like, I need a writ. And the judge says, well, take your writ, but I'm going to agree with the defense attorney. And he says, I want to put in all the programs that this young man has done on the record, which I find to be at the very least a good reason for me. He says, so I want his 100 hours of pre-release to be put in the record. He said, I want his Angola team CPR on the record. I want his dad program on the record, his self-help programs on the record, his certificates appreciation on the record. The judge says, I'm not done. He wants his Men of Faith thing there. He wants his Narcotics Anonymous put on the record. He wants his Alcoholics Anonymous stuff put on the record. His tip of the week completion, the Department of Parole put in the record. They want his service chip to be put in the record. They want his NA chip to be put in the record. They want his Vest Inmates program to be put in the record. I don't know. That's all that. He says, I want his programs that he's done on the record. And he says, Mr. Prosecutor, I understand what you're saying. And he says, I probably might agree with you, except for this time, we don't have the law in front of us. That's because you're not looking at it. You don't want to read it. He says, so I'm going with my gut feeling. I just believe he has done. And the prosecutor's like, I want to stop this. And he says, I want to stop this. I want to present the law to you. The judge says, you can present it to me, but I think my decision is final. So take it up with the Third Circuit. And he says, I am agreeing. And the prosecutor's like, no, I want him to stay in jail. The judge says, I have denied you, sir. And he says, I will say, but for him trying to rehabilitate himself, he would still be in there. And they say, however, we either believe in rehabilitation or we don't. And the defense attorney says, sir, are we granting? He's like, I'm granting this motion. He's like, it's not very often. I disagree with Judge Rubin or Roybin. Not very often at all. However, we can't ask for somebody to do better than what he did. So I said 2 days later, the trial court signed the order amending his 20-year sentence to time served and released him. And they say under these provisions, the court may correct an illegally excessive sentence at any time. There's no provision for amending an illegally lenient sentence, such as the one before us. They say that was not appealed by the state and has become a final judgment of the court. Yeah, well, that's the thing. Once it's done, it's done. You know, courts like finality. That's what they try to get. And they say even a legal sentence is reviewable under certain circumstances. So they say there are limits on a trial court's legal authority to conduct a review. And they say the Louisiana First Circuit reviewed the law pertaining to a trial court's authority to amend a sentence already. And they say there in that case, the court stated, and it goes on for a little bit here. I mean, that's like a whole page of block quoting. The court may amend or change sentence within the legal limits of its discretion. So that's what he can do there, but there's limits to what he can do here. And they point out the trial court exceeded its authority under the law by amending a sentence that was not legally excessive and sentenced the defendant to time served, ordering his immediate release. And they say the trial court clearly erred by illegally amending his sentence to time served and releasing him from custody. And they say that judgment is reversed and the defendant's 20-year sentence is reinstated. So notice they're saying it's too late for us to deal with the original sentence because that's done. We're left with the 20-year sentence. So the remaining assignments of error filed by the state are moot. So the application for post-conviction relief regarding his status is denied. A judgment of the trial court granting relief is reversed. And they say that the judgment of the trial court amending it is reversed and ordering his release from custody is reversed. So that's the thing. Like, he's got to go back into custody. His original sentence is reinstated. And they say he's ordered to serve the remainder of his original sentence. And they say the trial court is ordered to enter a minute entry that the defendant's original sentence is reinstated. So he goes back. He goes back to prison, guys. Whoa. Whoa. Do they really grow vegetables down in Louisiana? Yes. Yes. Full buddy. But yeah, there you go. EDW Raptor says, yeah, he participated in the cleanup all the time at the rodeo. Yes. The Angola penitentiary in the Indiana system has a rodeo. Yes, they have their own rodeo. They say so when the kid turns 18, it's not his problem. Oh, Ethan Crumley's, yeah. Yeah, that is what it is. It is what it is, chat. It is what it is. Hey, buddy. Hi. Come here. Hold on, chat. Hold on 1 second. Well, chat, we got... Oh, buddy, you're killing my headphones here. Come on. Uh-oh. Ah, there you go. Killed my headphones, Clyde. So this guy has to, yes, enjoy prison, stalker child. Yes, he has to go back to fucking prison. So that's rough, guys. That's rough. That's rough. That's what happens, though. If your sentence is wrong, it has to get fixed, and they will send you back to prison. You're like, well, that seems really fucking awful. But yeah, they're like suffer. So just yeah, I thought it was interesting. I thought that was interesting, guys. Where are we at right now? Okay, we are to this is kind of funny here. This hurts me because it involves the Michigan Wolverines, but oh well. Also, it's also very poignant with another somebody else we know out here, chat. So a ex-Michigan football coach is accused of stealing intimate photos from over 3,000 student accounts, the feds say. He illegally downloaded personal information of student athletes and gained access to their accounts. So there he is. So an NFL and college football coach was charged in a 24-count indictment with accessing the digital accounts of... Why is it doing that? Why is it doing that? It's so damn annoying. Okay. There. So if I do... I don't understand why it does that. Of 3,300 students to download their intimate photos and videos. So he faces 14 counts of unauthorized access to computers. Oh, buddy, I guess we know somebody who's doing that. And 10 counts of identity theft. The U.S. Attorney's Office in the Eastern District of Michigan says. He was there till January 2023 over allegations he unauthorized access to other people's computer accounts. I'm sure he just said, well, they left their Google in. I didn't do anything wrong. Yeah, well, there you go, chat. So, according to the indictment, he had a database managed by a third party that had information on the student athletes from more than 100 colleges and universities across the country. He's alleged to have done thorough compromising the passwords of staff members with elevated access to the database. After gaining access to the databases, he downloaded the personally identifying information and medical data of more than 150,000 athletes. Whoa, buddy. Wow. God, chat. Not good ideas. Not good ideas here. Not good ideas. Not good ideas. They say he cracked the encryption protecting athletes' passwords and conducted further research to obtain personal identifiers such as their mother's maiden names, pets, places of birth, and nicknames, according to the indictment. And that's the soft way, the social engineering of breaking passwords. So that's how they do that. So you ever see on Facebook where it's like, what's the name of the street you grew up on? That's people trying to farm for your passwords because people do that. And they use that shit as their passwords. And they say using all that information, Weiss either reset or guessed the passwords of 2,000 students, the indictment says. It alleges he targeted social media, email, and cloud storage of female student athletes. And they say once he obtained the access to the accounts, he searched for and shared intimate photos that were not publicly shared. He was also able to access the account of 1,300 students or alumni who attended institutions around the country. And they say in several instances, he exploited vulnerabilities and universities' account authentication processes. The courts don't list a record attorney for him yet, and it's unclear whether he's in custody. Whoa, man. Whoa, man. So each charge of unauthorized access to a computer carries a maximum of 5 years in federal prison. Conviction on an aggravated identity theft charge comes with a 2-year mandatory minimum sentence. Uh-oh. Oh, no. Oh, no. That's not good, chat. That's not good. So whatever you do, chat, don't do this shit. It's never a good idea. Never a good idea. This guy knew what he was doing, yeah. Yeah. Bob Johnson's like, Nick McCain said he could. Dust Boot says, is it $50 a photo? I get that reference. No, it is not $50 a photo. But don't do what this guy did. Don't do that kind of shit, chat. Don't do it. But yeah, this is a bit hilarioso here. A bit hilarioso. So just something to think about. Just something to think about that's out there. Oh my God. Oh my gosh. All right, chat. Moving on to a story we had here, and it's kind of one as we start off on. This is about bowhunters down in out west. And out west, guys, you have issues when you're hunting because you can hunt public land. You can hunt public land. You can hunt public land here out east. But in the west, the public land is like BLM land. You can hunt on real public land, like get lost on that public land. Here, you can hunt like in the Metro Park if you win a lottery. So that's public land. There are also some public hunting grounds you can use once in a while. They do exist. But this is the issue of when you're out west, especially, and even not out west. I've had this problem before, and you're like, well, I was a lot skinnier. When you're hunting, you find pieces of property that are corner locked, and corner locking is something that happens in corner locked land, and this is a good example of it because they talk about it in this article. This is a overlay of some area you can go hunt in. Now, the shaded areas are BLM lands, private land or public lands, and these unshaded areas are private land. Now, obviously, if I'm right here on the road, I'm on the road, I'm allowed to be on the road. So I stop here in the BLM area. And I walk, you can walk all over this area all you want. But what if you want to go to this place? It's landlocked. There's no direct route there. How do you get to it? Well, you can't go here. That's trespassing. You can't go here. That's trespassing. But chat, you can go down to where the corners are, because the corners are right here. And obviously, you can go like this. Boop. Oh, it's sharing the screen's not working. Oh, shit. Okay. Thanks, 2.0. All right. Sorry, chat. Sorry, guys. All right. So we're gonna restart this now. All right, Clipper. We need to rework this. So this is an example. All these highlighted areas are BLM lands, and these unshaded areas are private lands. And this is actually a very common thing out west. You have this checkerboard thing of land that's sold, land that's private. So let's say you're driving down the road here and you stop and you want to go hunting. So you get out here, you start walking along in this sector. Okay, so you could do whatever you want in this area. You can go all over the place. Perfectly free to do. Perfectly free to do. But let's say I want to go to another one. Because let's say the problem is everybody has access to this one. Everyone can walk to this one. But what about out here? If I want to go to this one or this one. If you notice, it's landlocked. And landlocked means there's no accessible way to get to it. Now, if I'm in here and I want to go north, if I'm here and I want to go here, well, I can't, the obvious thing you might say is, well, I'll go like this. You can't do that. That's trespassing. And you could get charged for that. You could get charged criminally, and you could also get sued for trespassing. And also the other big thing is you can't go this way because that's trespassing. Now, here's the thing. The hunting on these lands is a lot of big deal. But these private properties themselves are doing hunting too. They're hunting private lands. Some of them are ranches where they have private, like they grow and raise elk or other livestock that you can go out and hunt and kill. They don't want people wandering around their fucking properties. They also worry about people poaching. And they're going on here. And hold on, what's so that is, hold on, what is people? Well, we'll worry about that later. So if I want to get to this other spot, I have a problem. Now, what I could do is the corners meet up. Now, think about it. You can cross from corner to corner, and now you're okay. You cross from corner to corner. Now you're okay. And you cross from corner to corner. Now you're okay. Or I can go corner to corner. And notice I don't have to touch. I'm not touching you. And I can then get back out of the properties without touching the land. Luke, I saw what you're talking about. Now, Ag, you bring up a great point. What's to stop the private landowners from putting up a fence? Well, that's an issue. That's an issue because let's say there's a fence in the way. Well, there's a solution to that. And that's been an issue before. So what'll happen is this is the type of thing that'll happen. This happens. So there's a fence in the way, or there's a bunch of T-posts in the way that are chained together to obstruct you. Well, what do? Well, here it is, chat. You've got the thing. There's the corner, and here's the line you can't, so what do? You make a ladder and you climb up and over. That's how you get around it. You just take a ladder or something and you go up and over. And you start on friendly territory and you end on friendly territory. So you're avoiding the other lands, which in this case, it would be, I don't know, you can't really draw it on here, but this way you're staying on public property. And these guys, notice this is that sign. They are crossing that sign because they're hopping the fence. They're hopping the chains that were in the way. So that's how they do it. And it's a pretty creative way. It's a very creative way of handling the problem. I take a good scissor. People just West out petty. Dude. It's not petty. Like this Elk Mountain Ranch. There's a lot of fucking money involved in what they do and having private hunting leases. Because all this land that you're out here talking about, these are private hunting lands that they can lease out to people. I can turn around and sell a lease. I can lease it out to you for $10,000 for a season, and you can run around all over in here and hunt elk. Or maybe I break up my land into a bunch of different leases and hunters leases, and you get access to these, and now I can charge a bunch of money, and I can do 1, 2, 3, 4, 5, 6, 7, 8 hunting leases. I could do whatever I want with the land, and I have the right to do what I want with that land. And for a while, they saw these guys as trespassing. Well, but these guys weren't trespassing. They were just being very creative about getting it. They say the government doesn't just take the corners for easement. No. The government doesn't have to do that because there's no interest. They don't care about that land. They can get now. The government can always go get to the land if they wanted to, ultimately. But this is for just public people trying to get there. So they use the ladder. And they hop over. And they were sued for that. They were sued for trespassing. And the private landowners tried to get these guys arrested and charged with criminal trespassing under federal law. It was a real thing, and it went all the way up to the 10th Circuit. And the 10th Circuit rules that corner crossing is legal in at least 6 states. And that's the thing, chat. This is only applicable in the 10th Circuit. Now, it's not just bow hunters. If you like to go out and explore land out in the 10th Circuit, guess what? You get to do that now. You can take advantage of it. You have every right to use this in the 10th Circuit because, like, I'm not hunting. Okay, so yes, if you live in Wyoming, if you live in oh, geez, why did that not work? If you live in Wyoming, Utah, Colorado, Kansas, Oklahoma, or New Mexico, which, chat, these states are Wyoming, Utah, Colorado, very big hunting states. New Mexico's not bad in the north. Kansas, there's all kinds, like deer hunting there is huge. And Oklahoma has hunting pretty good as well. You are allowed to do the corner crossings. I'm probably going to go over the lawsuit at another point, but it's like 60 pages long. It's huge, so we're not going to do it today. And they say that no one may completely prevent or obstruct another from peacefully entering or freely passing over or through public lands. So yes, they make the argument for an easement, chat, that you can't obstruct people from peaceably entering the lands. And they said that this all came about because of 4 Missouri hunters, who had accessed a section of BLM land by crossing a corner shared on 2 sides by a private land owned by Iron Bar Ranch. The ranch had the hunters charged with criminal and civil trespass. And they cited their momentary presence in the airspace above the private land when they used the ladder. Now, this occurred all out in Wyoming. And the court there found the hunters innocent of the criminal charges. And the district court threw out the civil case. But the ranchers appealed, and the 10th Circuit decided that the public's legal right to corner access, the corner cross to access public land. And it helps everybody. It helps hunters, fishermen, and anybody who wants to go on public land. Because now anybody could do that. You can hop over all those squares, and you could bounce around. So this is a good thing. This is a good thing. It's a very good thing here, guys. This is actually a good idea. Some of you guys are making jokes about airspace. No, airspace is a real thing. We'll talk about that. So they talk about Bowhunters of America, which joined the lawsuit, supported it, and it was a lot of conservation groups celebrated it. And they say it's significant that 2 courts have now affirmed that what everybody else has argued, that you should be able to access lands that are owned by the government without fear of harassment or being cited for trespassing. And they're pointing out it's really sad these groups and landowners are being assholes. And they say this is prohibited respectful, lawful hunters from being able to access the wild places they enjoy. Yeah, chat, and that's the big deal here. And some of you might say, why would you want to go all the way back here if you're a hunter? Well, the problem is when you're on the road, when you're hunting public land, the problem is everybody hunts like right off this because everybody's lazy. So you're going to find like people all over here, like pretend there's trees everywhere. This is where all the hunters would be. Like 90% of hunters won't go this far. When you're on public lands, if you go over a mile inside public land, you will find no one. But you want to get away from them all. Okay, well, you want to go over here because there's going to be no one here. No one's going to walk that far. A lot of hunters are lazy. They won't walk that far. You go here. They don't like being out past dark, so you go all the way to here. There's a reason why you go to those tough places. You want to go to those tough places. That's where the good stuff is. That's where the good stuff is, chat. So they say across the West, there are millions of acres where the lands intermingle in the checkerboard pattern with alternating sections of land connected only at the corners. And the ranch claimed that the guys caused more than $7 million in damages. That's such bullshit. Such bullshit. So they point out this only applies within the 10th Circuit. So Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming are the only ones involved. And they point out that they are, this could always be appealed to the Supreme Court. Yeah, I mean, I guess it could. It would be hilarious to watch them panic, but yeah, they could appeal it. Remember, chat, Supreme Court does not have to hear the appeal. So you'll find out what happens there. But yes, this goes back through all the land management that's gone on, the homesteading acts, Wyoming's range wars between cattle and sheep owners. Yeah. And they point out the hunters never made contact with the land. They never touched the property. And there's no evidence they damaged or made contact with the property. So they ultimately went back to an 1885 law, the Unlawful Enclosures Act, saying that, it harmonizes the rights of private landowners and those accessing public lands. So they say any enclosure of public lands is prohibited, and no one may completely prevent or obstruct another from peacefully entering or freely passing over or through public lands. So that is there, and these guys have violated a law. Now, do the people involved in this care that much? No, I think they're happy with just getting what they wanted out of this. But yeah, the Iron Bar Ranch sounds like a prison or like a really awkward gay. The Iron Bar. Yes. It's always hard, chat. That's always hard. Oh. Make sure you bring Clyde. He uses the corners too. Well, I'll just let Clyde go wherever he wants. I would like to put no trespassing signs around my public hunting spots. Oh, don't do that. Don't do that. That's not fun. That's never cool. Kia Paddock says, go hunt Nevada. It's like 96% BLM land. Yeah, but you're not going to get, not all of it's land that you're going to want to hunt things on. So, but you guys were making some comments here about the airspace. That is, Tech Guy South says, build a church on that land. Yes. Pete says, base ladder, bros. Yes, you can hunt pheasant in Kansas. Yes. The deer's good in Kansas too, though. And Nero says, as a landowner, you also have air rights above your property. That ladder does trespass on the air rights of the landowners in the most de minimis way possible. The people are trying to access landlocked land. So no, that's why the court's like, nah, bro, nah. No, that ain't gonna happen. They're not gonna count that. Pitchlock says airspace. Yes. Airspace is a violation. Like you can take a drone and fly it over your neighbor's house. You can trespass. You don't own infinitely all the way up to the edge of space, but you own up to about at least 100 feet. I think sometimes, depending on the FAA reg, it could be up to 200 feet above your house. There are rules on that, so you don't just get to that theoretically, though, if you own the land on your house and you own it free and there's no mineral rights or anything, you own from here all the way down to the center of the earth. But you don't own all the way up to the edge of space. That's not how that works, sadly. But violating your airspace can be an issue. Don't be the guy who does that. Don't be the guy who does it. Oh. What if they wore stilts? That would be also a funny option. That would be funny. That would be funny. I don't know how you would do that, though. Yes, people laugh about airspace rights until your neighbors start droning over your house and, staring at your daughter in the swimming pool. Yeah, I mean, airspace rights are a serious problem. Yeah, space is Class E airspace. Oh. They want high jumping bow hunters. You gotta just up and over the back. That's the only way you get to it. You have to pogo stick your way over. No, I think it's a far safer way. So that is there, guys. Like I said, I thought that was a very interesting one. What is it going to happen for them? How are they going to get this to work? All these things are going to happen to it. And it's just this idea of this, this just mindset that you're not allowed to do this. It's like, that's no fair. Auto Doctor says, how is it that as big as Texas is, there can be no public land for hunting? It's because in Texas, everybody bought up the land, man. It was suitable land for cattle ranching. And unlike a lot of the West, Texas had a couple hundred years of colonization going on by the time the Mexican-American War came along. There were a lot of people there. And then in the panhandles and out west, like the cattle people came in and just snarfed it all up because they realized how good it was. So that's what happens. That's how that stuff happens. That's how that stuff happens. Will you cover the honey lawsuit that Gamers Nexus filed? Is there a new honey lawsuit, or is that the same lawsuit for honey where like honey's just scamming everybody and rips off all their stuff? Where Tiger Ray? Not sure which one you're doing there. Did I see the text Slaughter refusing to pay out a ticket? What? Hold on here. I'm gonna Google that just so I have it. Oh, yeah. Wow. Oh, well, they're investigating. They're taking a look at it. Okay, so they're she's saying that the ticket had been purchased via an online app. Okay. So that's interesting. I don't know how you buy lottery tickets online. She bought it through like Uber Eats or one of those things where they buy, like, I didn't know that's legal, but okay. That works. That works. Has anything new happened with the basic bitch lawsuit? I don't think so yet. I'll take a look at it though. We'll keep that as an update topic. All right, guys, moving on from there. This was kind of interesting. Kind of interesting, but also in a totally weird kind of like way. We have get rid of that, 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 get rid of that. All right. Let's see here. Where is? Okay. So we're going to move on to the stuff involving Trump. That's kind of the next big frontier here. And this is something I'm just going to bring up. I know people are talking about we need to impeach judges. It's never going to work. Remember, if you impeach, you still need like a 2/3 Senate removal requirement. So you're not going to get it. So the impeachment will be limp-dicked. The first one will be historic and mean something, just like a Trump. And the second impeachment is like, who gives a fuck? Nobody cares. So don't do that. Don't do it that way. Don't do it that way. Oh. But from here, they are dealing with Chief Justice Roberts made a statement about this, and he put it out there. And yeah, things are getting spicy, chat, as we go here. I don't know why it does that so many times. So it says Roberts rebukes Trump and the GOP rhetoric about impeaching judges. Notice he didn't run his mouth when like the Democrats were talking about packing the court and shit and ruining your institution's ability to govern. He just sat there and took it. Like a complete turd. Like a complete turd. So anyways, Chief Justice Roberts pushed back on Trump's claims about, impeaching judges. And he says, for more than 2 centuries, it's been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. Yeah, but we're not really having a disagreement. We're literally having what happens when the judges start doing whatever the fuck they want, and it's not fair to us because nobody's holding them accountable. Like, literally, that's not a good thing. That's not a good thing here. Roberts is straight up garbage. Yeah. Says, how many administrations these douchebags go? Well, John Roberts was appointed by G.W. Bush, so GWB. So he's been around for a while. And Roberts said in a statement released by the Supreme Court, he says the normal appellate review process exists for that purpose. Yeah, except when it doesn't work. And Roberts didn't mention Trump by name, but it came hours after the president stepped up his attacks on judges, specifically Judge James Boasberg, who has temporarily blocked the deportation of the trendy arugula guys and the gang. So that is where we are with this. There's not a whole lot as far as things to look at, because really Trump is just going around acting crazy. And yeah, that's what it is. So he's already trying to say, look, don't do this. Leave my heckin' Reno courts alone. Yes, it's also not really a judicial decision. I agree. That's a shame. It's a judicial action. It's the TROs. Yes, that's the problem. Yes, it's not the fact judges are ruling on stuff. They got to make rulings, but it's they're granting these temporary restraining orders against the government. It's like, nah, who the hell are you? So this is why we're giving CNN views, because I think you got to look at it from different places. That's why we're doing it here. Now, moving on to Judge Boasberg and what's going on in the Trump case with the trendy arugula boys. If you guys remember, this is one of the orders he published, and this is where he says, the government is enjoined from removing the members of such class pursuant due to proclamation for 14 days until further order of the court. That's pretty straightforward. It's pretty straightforward. But the judge, it's clear the judge is kind of like, it didn't work the way he wanted to, because he had to come up with another entry about this. And he's like, why are you guys, why is nobody listening to me? Why is nobody listening to me? Now, this is where he has asked the government, why are you doing this? And they've said, oh, well, we're not sure. And he's like, I demand answers. I demand answers. I demand answers. And we're now getting to the issue of, is Trump to the point where he can ignore the courts? Because Judge Boasberg has asked for a lot of information, and this is really kind of going to hinge on a couple different things here. And the government has said, like, look, the planes are already in the air, and we have state secrets. We can't talk to you about things. And I think it's far easier for the government to say, look, the planes are in the air. We've already negotiated with the Salvadoran government, so there's nothing we can do. You're just like, yeah. I mean, there probably are some things you could do, but I also get the idea of saying, fuck you, we're going to do what we want here. But that is where we are. This is, can we ignore the courts record federal trials? No. But what happened here is the judge did put out an order, though. And he says on March 18th, the court ordered the defendants to provide by noon the following day, so yesterday, the information regarding flights carrying the individual subject to the court's temporary TRO that was filed initially. So the defendants instead filed a pleading shortly before the deadline, seeking the stay of the order on the ground. They were considering whether to invoke the state secrets privilege, which is something they could do. They could say it's a very critical secret. We can't share it. And therefore, you guys can't do anything about it. Now, is that going to work? Well, the judge says, although skeptical of the applicability of such privilege, the court granted another 24 hours to release the information ordered or invoke the privilege. And they say, in an ex parte pleading delivered shortly after today's deadline, the government again evaded its obligations. Well, according to him, they say it submitted a 6-page declaration from the acting field office director for enforcement and removal operations at U.S. Immigration and Customs Enforcement, Harlingen, Texas. Did I get that right? Harlingen, Texas field office. And the contents of which the government has informed the court may be disclosed. And they say after 4 paragraphs of identifying information, he repeated the same general information about the flights. And he says on May 15th, 2 flights carrying aliens were removed under the AEA departed airspace before the court's minutes order later. And they said the court's oral statements during the hearing of, and this is where he says, I understand the cabinet secretaries are currently actively considering whether to invoke the state secret privilege over other facts requested. He says, doing so is a serious matter that requires careful consideration of national security and foreign relations. It can't properly be undertaken in just 24 hours. He says this is woefully insufficient. He says, to begin with, the government cannot proffer a regionalized official. And they say, indeed, his declaration on that point, not surprisingly, is based only on unsubstantiated understanding. So they talk about the skepticism concerning the availability and suitability of such privilege. And they express in the order, the court at a minimum requires an official with direct involvement to swear the deliberations of the privilege invocation are ongoing, at least at the levels attested. I think that's not your fucking job at this point. Like, I mean, it's just ridiculous here. Just let it go, Judge. Jesus Christ, homie. They say it further expects such deliberations to be concluded by May 25th, 2025, which only exceedingly good cause may excuse. So that's where we are at the next step. And they say, in addition to avoid further delay, the court will require the defendants, and that means the government, to show cause on the facts they have already disclosed as to why the failure to claim the return members about the earliest planes did not violate the court's TROs. And they say further supplementation may be required once particularities are ultimately disclosed. So they go through this, and it's the judge here, and he's saying, so by March 21st at 10 a.m., so that means by Friday, they shall have a sworn declaration with direct involvement in the cabinet level discussions. And that's where this goes. And they talked about, will they invoke the state secrets privilege? They're saying that the defendant shall submit a declaration indicating whether or not they'll say whether or not they're going to do this. So the government has to say we're going to invoke the privilege. By March 25th, the defendant shall file a reply brief showing why they did not violate the TRO by failing to return class members removed from the U.S. on the two earliest planes. And they say the plaintiffs may file any response to such brief. So, and this is from the judge. You guys are shitting on Pam Bondi. Well, I don't know. Guys are going to have to suffer. She's not going anywhere now. So, she's not going anywhere now. So, from here, guys, what's going to happen? I don't know. I think that it's going to go all the way up. This is going to be the showdown. It's not going to be resolved. But that is kind of the big update for all the Trump stuff right now. That is kind of the big update. Terba says, this hurts me right in the Americas. Well, that's no good. That's no good. Hurts you right in your Americas. Pow! Right in the America. This judge is trying to act as SCOTUS. Yeah, he's trying to do a lot of things. And it's not going to work out well for him at the end. He's going to get felted, so knock on wood, that SCOTUS does their job. I mean, remember, we have 4 justices already who are like, stop this shit. We're not doing it. So, why does the government get less than 24 hours, but the plaintiffs get 10 days? Well, because technically the government's had a couple of days, and to be fair, the way the judge is describing it, they won't give the clear answer. I mean, and if their answer is just fuck off, we're not telling you, then just give that answer. But the answers they've given have been pretty shitty. So far. Somebody's saying, who enforces the TRO? Well, we all do. So, it says, who enforces the TRO? Well, I mean, it's through the court, and the court could sanction you and fine you if you're not doing it. See, that's the thing. If you can be punished, and the court can do that. It's not like there's going to be the court at some point could order the marshals to come get you or something to happen like that. But generally, that's not what it's going to come down to. Other parties will get sanctioned out. Is typically what happens. So. That was about to sneeze. Didn't stop. So let's see here. What else you guys got? Geopathic says Marbury versus Medicine says you're the law. That's good. The marshals work for the president, though, right? Yeah, they work for the DOJ. Now, all depends. Like, some of them are going to be, pretty willing to do what the judge says there. So, did you miss anything? No, it's been really gay here. So, Clyde's pumping fent in my office. Yeah. It's just been a long couple of days. It's been a long couple of freaking days. Let me tell you what, Chad. Let me tell you what. But that is where we go from here. And then I guess kind of ending on a weird note tonight. This is a little weird how this happened here. But in Louisiana, they are back to, and the couple states are back to doing executions this year. In Louisiana, this one here, speaking of pumping fentanyl, Louisiana is using nitrogen gas to execute a guy. And they did it yesterday. So they decided to push through this, and they resumed convictions, and it's been a long time since they did it. They haven't done it since 2010, and they used nitrogen gas, a method that was first used by Alabama last year, and it's been legalized in Louisiana. Now, the reason is they're using all these things because back in 2010, they ran into problems because, remember, guys, the companies that gave you the drugs for lethal injections, there were challenges to it, but also the companies, like there's one company in the Netherlands, they made a bunch of the drugs. Well, they're like, we're not selling to you anymore. So you couldn't do anything with it. And with that, the lethal injections got put on hold. Now, they talk about the guy who got put to death. His name is Jesse Hoffman. He was put to death on Tuesday for the abduction, rape, and killing of a Molly Elliott somewhere in New Orleans. And they say that he had declined to give a final statement before he got executed. And they say that they pumped nitrogen gas into a mask, affixed to him for 19 minutes, and he was pronounced dead afterwards. And let me see here. They say the execution went about as good as we could have expected it to be. Well, it's better than the one in the Green Mile that went bad. Maddie says we breathe with over 80% nitrogen. Yeah, but that's yeah. They said he convulsed for about 2 minutes after it began flowing, and they said he did not believe that he was conscious when he convulsed. I mean, I could see that being the case. I could see that being an issue. But yeah, that's they say he did move, he did shake very briefly. So yeah. Now, if you guys haven't seen it, they do have a picture of the mask here, and you're like, oh, that looks like a firefighter's mask. I mean, yeah, it's kind of like self-contained breathing apparatus. But I think it looks very nifty. And instead of, the first time you're thinking, like, when they do this, though, they would just pump a room full of the nitrogen gas. And that would have been a very interesting way to do it. Like, you're locked in, because that's the way. At times I feel like an idiot because I was thinking, well, like, how do they do, like, when they had the gas chamber, they would have cyanide gas, but you're in, like, this little enclosed room where the crystals get dropped into the acid, and it's like, and that's how it kills you. But this one, we're now, like, modern technology require modern solutions. So they just stick the mask on your head and, like, the bugs eat you to death or something, I guess. I don't know. Yes, the slow forever sleep. Access, I have one of these in the lab. That's a huge amount to displace. Yeah. Michael says the key was having wooden doors. Like, yeah. Amateur iconoclasts, they sell the drugs in Canada for the assisted suicide. Probably. But remember, they're going to say that's different. Yeah, it's different. And yeah, it kind of is. Kind of is different. So, mean, there's only so much you can do there with it, but yeah, this is a photo of the thing, and they put it on him, and they like, oh wow, and he's like, he's like, I'm Luke, I'm your father. Like, I wonder how he did it all. Nitric and gas is kind of expensive, really? I didn't know that, huh? Well, be very careful. Be very careful on nitrogen gas, chat. Don't go breathing in anhydrous ammonia fumes. That'll be really bad. So that is where we are, guys. Have I seen the new suicide pod invention? Yes, that is fucking insane what they do there. That is insane how they do that. Ritual Braveheart style. Yeah, no thank you. No thank you. So guys, we are Patty F says there isn't enough fentanyl out there for the states to use, yeah. Well, it's interesting. It's interesting how that all. Wow, Clyde got all fired up. He's just like out in the hallway laying down. All of a sudden, he's just like, ah! Well, there we go. There's 2.0. Yes, not the bugs. Not the bugs! Thanks, Nate. All right. So we're all caught up, chat. We are going to end this here tonight. End a little early. Because I needed to. I need to end a little early. So I'm sorry tonight. That means we'll start locals a little earlier. Richard Gruber for $5 says, I got a raise and my crybaby coworker got fired this week. Let's fucking go. Yes, let's go, chat. Let's go. Also, once again, with the ever timeless drum magazine for the AK. Very nice. Jules has been a member for 2 months. Says, I'm going to buy a drum mag just because I can. Yeah. Kind of makes me want to do that every time I see it. Squizgar says, imagine not being green. It's cringe. It's like, yeah, it is. It is. Like, come on, guys. You gotta want to do it. You gotta want to do it. That said, the Squizgars with 10 subs tonight, chat. 10 subs. He's doing his part, chat. He's doing his part to crush up the Grays and spread the banner of the green supremacy. He's doing his part out there, chat. Just flattening all of you. I mean, just look at those gray cars just getting fucking crushed by that green truck. That's a sign, chat. That's a sign from the heavens. Something you need to think about. It's a sign from the heavens. It's a sign from the heavens. Maddie B says, member for 8 months, says, come and take it. Well, there you go. That is a very nice thing there. Wrestler Town gifting 5 subs. Thank you, Wrestler Town. It's good to see you, by the way. It's good to see you, by the way. Very good to see you. The gray card did get crushed, chat. It does get crushed. We're not playing this game tonight. It gets crushed. But thank you, Wrestler Town, for your gift and your generosity. Squizguard, thank you as well for your gift and your generosity. But it says Bebop and Rocksteady says, the courts are acting wild. Should Trump just trust the plan? Or should he go full Andrew Jackson? Show your work. Well, I don't think he should trust the plan. Don't trust Sessions and all that. Do I think they should stick with whatever plan they've developed? Yes, they should stick with whatever plan they developed and see it through. I think they should avoid getting baited into dealing with the left in court because they'll win, but they're going to, at what price? So that's where I think it's critical to make sure it's, what's the price tag going to be? Because you need to make an honest assessment of it. They say, Grassroots Hegemon says, you ever go hunting, Sean? You catch the good ones in suburban areas with your hoods. I mean, yes, I had a stretch where when I was in law school, and not since then. that I hit like a deer a year for like 4 years. It was ridiculous. It was fucking ridiculous. I remember the one time I did, I hit a baby, fawn, like crossing the Ohio Turnpike. I was going like 80 when I just like right into it. I hit it so hard I knocked the spots off it. Let me tell you what. Johan says, chat, we have to go buy an HO train set decor. Also, we have to go be one of these corners and place it there. You want to build your church on that land, bish? Ah, yes. DF88 says, Andrew Jackson to the court. That's nice and all, but I have an army. Enforce it, bitch. And then EDW Raptor gifting 10 subs, chat. 10. He's doing his part tonight. Are you doing yours? You doing your part to fight this gray menace?
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part too.
They're doing their part. Are you?
Are you? Should do it like the Lord Kitchener's thing, like the Uncle Sam thing. Like, I don't know how that worked. Nico says the sun never sets on the gun to Empire. Yeah, well. Oh no. Oh no, chat. That's no good. That's no good. Some of you guys are not being very nice tonight. Well, you guys aren't having trouble building towers over in locals. That's guys got to work on your towers. Come on, you're repping the set out here, and you guys can't build a tower right. I mean, oh gosh. Never mind. I thought that joke's not going to work. We're not going to do it. Pete saying, oh, it's a huge amount to displace of the nitrogen. I'm like, yeah, I guess. No, wait here. Hold on. You guys are doing OJ. I thought you were doing Ouija for a second. OJ. Yeah, it doesn't work, chat. So, William Wall says that damn clip from the shitty movie. Yes. Unhung Heroes been a member 13 months says, I did my part. Thank you for the support, man. I appreciate it. Thank you there. OJ did it. Yeah. Well, yes. Well, see, OJ didn't do it. His son did it. An Unhung Hero for 10 subs. Let's go, chat. Let's. Good. Thank you, Unhung Hero. Appreciate the support, man. I appreciate it very, very much. Guys, make sure you have gifts turned on if you want to receive a membership for people out here in chat that they are giving them away. Let's see. What else we got? I think we're all set up there. His son was at work. It's been debunked. Well, has it been debunked? I didn't think it had. I didn't think it had been debunked. I'm going to have to look into that. I'm going to have to look into that. Yes. Unhung Hero says, keep praying the gray away in the hat. Yes. I've never heard this thing about the sun. Yeah, I'm like, I don't know how that would work. OJ's son was at work cutting up white meat. Ah! Well, and Ron Goldman, he was running a kosher deli too. His deli broke kosher when he was killing Ron Goldman. Oh no, chat. That's not good. That's not good. Blade 2.0. Remember, chat, it's the second iteration of the Blade. It's been a member for 2 months. Thank you again for the support, man. It says 07. Great stream. Well, thank you very much. Oh, so let me see here. Yeah. If you use an ad blocker, you will never be gifted. Really? Huh. I'll have to take a look at that. Say, try it some more. Okay, I'll take a look at it. So, let's see here. What are you? Say Ron Coleman, I thought he was defending the slants back then. Yeah. So, yes, it was a special on OJ's Innocent or some shit with 2 retired detectives. They went to the restaurant he worked at. Huh. Uh-oh, what is this? Not a shower text chat. I'm just looking at something here. Oh, yeah, I've seen this. I've seen it. Trying for your ad blocks, yeah. He was running the pastrami shop when he cut up Ron. Oh, God. That's... He's actually opening a Pez dispenser shop. That's how he turned Nicole's head into a Pez dispenser. Oh, okay. It's a rooftop Koreans, yeah. So... Your bracket's already fucked? Well, that sucks. I forgot that's going there. Yes, I did hear in the Karen Reed case that the prosecutor added Karen Reed's attorneys as witnesses because he's a smarmy little shitbag. But that should be, he should be punished for that. So it's very awkward that he did that. Guys, the Karen Reed hearing today was massive. So we might watch it to catch up on it, but I did hear clips a little bit as I was running around. I listened to Emily Baker a little bit covering it. I forget who else I listened to, but yeah, there's just a ton of it to get to. So hold on, chat. Bless you. All right. So, all right, guys. So we are all done here. We're all caught up. We are going to move on. And we are going to get ready for locals. Remember, chat over at potentiallycriminal.locals.com. Promo code WHIPIT so you can come hang out with us. With that said, guys, we've got an interesting week coming up tomorrow night. We've got the conventions. 2 conventions here in Ohio are suing each other. And it's the OhioCon lawsuit. As somebody brought to me, I had a chance to read through it and catch up on the lore. It's interesting. It's interesting. I never heard of it, and that's a pretty funny name for a con here in Ohio. So we're going to cover that. We're going to cover some of the Karen Reed stuff over the weekend. I'm going to see maybe if there's time to get into this 10th Circuit case about the Bowhunters, or if the 9th Circuit case, if Runkle or somebody else is free, take a chance at it and see what we can do. Joe says, how's your trial prep going? Well, we're trying to figure that out right now. We're working on some things, so that'll be interesting coming up. Doesn't involve furries, kind of. It kind of involves furries. Kind of involves furries just a little bit, sadly. Sadly, it does. It's a con. There's furries involved. So with that said, chat, remember until next time, and like I said, you'll get some, we'll get some dates going here. Also, Chinese Grand Prix this weekend. So chat, remember until next time, just because you did it does not mean you're guilty. It's not mean you're guilty. Unless you stole like 150,000 students' personal insurance information, then you're probably guilty. Don't be that guy. Don't be that guy, chat. Don't do unauthorized access to computers. It's not cool. It's not cool. Nobody will tell you it's funny. It's not funny and it's not weird. Don't do it. Don't do it, chat. So thank you guys and have a good night. See you guys over at Locals.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?